Welcome to WG University Weber Gallagher series of educational programs. This is our commercial transportation webinar series. I'm Jim Wesco, and I'm presenting today with Katie Tenzinger from our Philadelphia office. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher website at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is called The Intersection of Criminal Law and Trucking. Send lawyers, guns, and money. So let's get started. What we're going to be talking about today is I'll give you a brief overview before we get started. What we're going to be talking about today is not only the critical importance of having counsel involved in first responses for serious accidents, but also coordinating when necessary with criminal defense counsel to make sure that the driver's constitutional rights are protected. And in doing so, when you're making sure that the driver's constitutional rights are protected, you're also at the same time protecting the company's interests in pending civil litigation. So we're going to go through the accident, first response, and the role of an attorney in a first response. We're going to talk about the company's involvement before the attorney arrives, because that's often the situation that the attorney can't arrive at an accident scene, sometimes until several hours after it happens, and the company representatives are usually there much earlier. We're going to talk about the accident investigation and how it may affect or be adverse to or consistent with the driver's Fifth Amendment rights. We're going to talk about the importance of minimizing the driver's involvement at the scene. We're going to touch upon the Federal Motor Carrier Safety Administration's duty to assist and protecting evidence at the scene. We're going to talk about Section 390.15 of the Federal Motor Carrier Safety Regulations, which involves the carrier's accident reporting and duty to provide information to authorities and how that affects drivers' rights. We're going to talk about the National Transportation Safety Board in more serious accidents involving multiple fatalities. Often they're involved, and we're going to talk about how that affects first responses and what you need to do to protect the driver's interests. We're also going to talk about when and how to get a criminal attorney involved to protect the driver's rights, who should be doing that, and the timing of that. We're going to talk about how, when a criminal attorney is retained, how to coordinate his or her actions with the civil defense attorney to make sure, again, that the driver's interests are protected. We're going to talk about situations when there may be criminal charges filed or being considered by the law enforcement agencies, and how that will affect the civil lawsuit, and if the case is in suit civilly, when you may want to consider requesting a stay of all or some of the proceedings pending the outcome of the criminal case. We're going to also talk about the effects of a plea deal or a verdict in a criminal trial and what that does to your civil case. So Katie is now going to talk about the role of the attorney in a first response and the various aspects of the first response that go along with it.
So when Jim and I were discussing this presentation and specifically this topic, we tried to come up with a good analogy for what an attorney is supposed to do when they get on the accident scene. And the best analogy we came up with is that they're supposed to be the quarterback. So the attorney's goal is to attack the accident from all different angles and all different levels to make sure that the company and the driver are well protected. And you'll see on the slide, there's a few reasons why and how the attorney does this. One is communication. And by that, we mean not only with those on the accident scene, but also with those investigating the accident and those back at home base with the trucking company. An attorney is able to provide immediate on-scene evaluation of the exposure. By having someone who's familiar with the local jurisdiction, they can assess, the potential injuries and claims that your company and your driver could be facing down the road, and at least give you an initial evaluation of what that risk could be. Perhaps one of their most valuable functions is to coordinate the experts who will be involved in the accident investigation. Depending on the size and severity, there's often a field investigator involved, as well as maybe a photographer or an accident reconstructionist. While it may be tempting to combine all these functions into one expert, one thing we discussed is perhaps hiring different people so that everybody can focus on their own expertise. Obviously, certain circumstances warrant that, while others do not. An on-scene attorney will help to coordinate and direct the efforts of all of the experts, making sure that they account for all of the important information that needs to be accounted for, and to make sure that unnecessary things are not focused on. Plus, the attorney being involved triggers attorney-client privilege, so that will protect the accident investigation materials down the line should litigation ensue. And lastly, the attorney should have immediate contact with the driver to make sure that they understand what happened during the accident and any of the investigation that happened thereafter. When we say secure evidence and information, the tractor cab is much like the driver's house. It's where the driver stores loads of personal information and items. You wouldn't want a police officer or an opposing attorney to kind of go through your house unsupervised, so we wouldn't recommend that with a tractor cab either. It's important to have someone there to make sure that medication, information about pets, phone numbers, or phones or electronic equipment doesn't fall into the wrong hands. Opposing counsel like to make much of a driver's health or other distractions that may have contributed to the accident, and the tractor cab certainly serves as a candy store for them in making those arguments. With respect to logs, are obviously a very important part of the accident investigation. They need to be retained and preserved. The on-scene attorney will act as a middleman with the investigating authorities and the trucking company and the driver. The attorney will know what information needs to be produced and what information does not, and will not let the investigators overstep their bounds in that regard. When we say investigating authorities, that could be police officers, but it could also be the other involved vehicles, field investigator who is there. And oftentimes a driver is encouraged to cooperate with everyone there, but doesn't necessarily have any duty to. The attorney is the last person standing between your company and the jury at the end of the day. And so it's important that they have immediate involvement to create a complete defense. And as mentioned before, the on-scene attorney will act as a quarterback, so directing the accident response. And one of these responsibilities is to control the outflow of information. So that would mean communicating with media, as well as instructing the driver and maybe any driver's family members about what they can and cannot post on social media. Everybody's on Twitter and Instagram and Facebook these days, and people post in a knee-jerk reaction, but without probably the necessary foresight. So it's important to make sure that the Twitter post from your driver's sister doesn't hurt you down the line in future litigation. So we talked about what happens when the attorney gets to the accident scene, but obviously there are steps that may need to be taken before the attorney arrives. So some potential actions that the company can take are making sure that there is an accident reconstructionist as well as a field investigator that you are comfortable with and are able to dispatch to an accident scene at a moment's notice. The company should also consider having a letter on file that explains to the experts that they're being retained in anticipation of litigation. That's important information and important language that will help to trigger a privilege known as the work product privilege, which will protect all of that information and communication down the line in litigation. Some of the concerns with a company's involvement before an attorney arrives is the non-privileged nature of communications. So any communications that the company may have with other employees or with experts that are outside the bounds of being discussed with the attorney could certainly be discovered by a opposing counsel in litigation. Additionally, we touched on it a little bit before, but everyone is always encouraged and eager to cooperate with the investigating authorities immediately after an accident, and sometimes providing too much information in the sense of being cooperative can hurt you down the line and put you in a compromising position. Also, it's important to consider that those non-attorneys involved in the accident have a different perspective of things. For example, your adjuster who's sitting down in Florida may not understand the issues and laws and processes associated with an accident in the state of New York. So retaining local counsel to assist in flushing out those issues is very important and recommended.
Thank you, Katie. What I'm going to talk about now is the interaction and potential conflict that occurs in more serious accidents where we have situations where, in addition to the attorney's role in protecting the company's interests and the driver's interests in anticipation of future civil litigation, whether it be wrongful death or personal injury litigation, there's also the possibility that the driver is going to be charged criminally for his conduct in causing the accident. And what we're really talking about here is making sure that the driver, at least with respect to the initial investigation, doesn't do something or say something that could violate or prejudice his or her Fifth Amendment protections. As we know, the Fifth Amendment protects people from self-incrimination. It protects them and provides due process so that they can have an attorney to assist them in these types of situations. So we're going to talk about situations where the police and the investigating authorities, in addition to looking at an accident to determine causation, are also looking at it at the same time with an eye towards charging the driver with a criminal offense, such as negligent homicide or something along those lines. So there are a lot of potential constitutional issues that arise in that. And as I just said, when the state police are at an accident scene and they're reviewing or investigating the accident and trying to determine the cause of it, they're also at the same time looking through a different lens, and that's to see if there's any basis to charge the driver, either driver, but in your case, we're concerned about the truck driver, whether or not there's a sufficient cause or probable cause to charge the driver with some criminal offense associated with his or her conduct in causing the accident. So you need an attorney at the scene to identify those types of situations and take the appropriate steps to intervene in those types of situations. You also need to make sure that the company people who are assigned or dispatched to the accident scene as soon as it happens to be aware of these types of situations where there might be a potential criminal charge arising from the accident. So they need to know when situations arise where the driver's constitutional rights might be adversely affected. And what we're really talking about here is a situation where the driver is, in his or her perspective, being forced to provide information to law enforcement authorities in what we call a non-custodial situation. For example, if there's a driver who's at an accident scene and he or she is taken, say, for example, into the back of an ambulance or a fire truck to receive some medical attention, and a state trooper would come into the ambulance and the driver is in a semi-restrained situation, or he or she may be in a medical condition to not allow that person to just get up and leave, and the state trooper starts asking questions without what we call giving a Mirandization of the driver. And as most of us know, that if the police are going to conduct an interrogation of you in a situation where there's a custodial situation, i.e. where you're not allowed to leave, they have to read you your Miranda rights, which they have to tell you that you have the right to remain silent and you have the right to counsel. Well, if the driver's laying in the back of an ambulance and the state trooper's the only one in there and the doors are closed, the driver's not going to have the sophistication or knowledge to know that he or she can get up and leave. So he or she is going to perhaps say some things that may incriminate the driver, And as the attorney present at the scene, or if a company representative is at the scene who's cognizant of these potential risks, they can intervene and make sure that the driver's rights are protected, either by having the trooper Mirandize the witness so they know their rights, or to terminate the interview until that is resolved. The drivers often at the scene are in a state of emotional imbalance. They may have suffered some physical injury, regardless of the fact of whether or not the driver walks away from the scene. When there are serious injuries involved or casualties involved, fatalities involved, the driver is almost always mentally traumatized and is in no condition to be giving statements that may or may not affect his or her future, particularly if it involves future incarceration. So it's critically important at this initial stage to have someone there to intervene to make sure the driver's interests are protected. Obviously, there's a great sophistication imbalance between law enforcement professionals who are trained to identify certain factors and question people, and they're also trained, quite frankly, to put drivers in situations where they're going to feel maybe not intimidated, certainly, but pressured or led to believe that they don't have a choice into doing anything other than cooperating. And the drivers don't know that because they wouldn't be sophisticated enough to know that. They don't have the legal training or experience to know when they're allowed to keep their mouth shut. And the state troopers are trained through experience to get information at that initial level. And one of the things that the drivers, this is a Pennsylvania statute, but one of the most common types of situations that a driver will face is criminally negligent homicide or involuntary manslaughter. And that's a situation where there's an unintentional killing that results from recklessness or criminal negligence, or from an unlawful act that is a misdemeanor or low-level felony by itself, such as a DUI or speeding. Now, hopefully our drivers aren't going to be at risk of a DUI when they're operating a motor vehicle or a commercial motor vehicle, but certainly speeding is one of those things that is a factor that can be considered by the investigating authorities as to whether or not there's criminally negligent conduct. And we'll talk about a few of those other things shortly, but there are elements to this particular crime. Obviously, someone has to be killed, and the act was either inherently dangerous to others or done with a reckless disregard for human life. And the defendant knew or should have known, the driver knew or should have known that his or her conduct was a potential threat to others. What are some of these situations? Well, running a red light could arguably be considered something that the driver knew to be particularly hazardous to human life, but did it anyway. Certainly speeding, and especially speeding in a restricted speed zone, such as a construction zone. The courts in Pennsylvania have been particularly eager to find criminally negligent behavior in those types of situations. When you have a situation where traffic is stopped because of construction and a driver slams into the back of the line of traffic, we've seen situations where drivers are frequently charged in those types of accidents. Driving while fatigued is certainly something the driver would presumably know that he or she is over the federally mandated hours of service, and deciding to drive into those situations when you're fatigued could arguably be considered some criminally negligent conduct. The same thing with being on medications and not taking them. Many times drivers are out for 2 or 3 weeks at a time and their prescriptions expire and they don't get them filled till they come home. Well, if an accident happens involving fatalities during that interval when they're not on their meds, and the plaintiff's attorney or the investigating authorities determine that is conduct that was criminally negligent, you could have a problem there. Obviously, texting while driving, road rage, and racing, which shouldn't be applicable to commercial motor vehicles, but these are all things that give you an example of what could be considered criminally negligent conduct. And one of the consequences, if the driver is charged, convicted, or found guilty of these types of crimes, is that the criminal plea only resolves the criminal case. It does nothing whatsoever with respect to the civil case. The criminal plea can be used against the driver in a civil case. There are also situations perhaps when the insurance that's in place to protect the driver and the company for civil liabilities associated to the accident could be adversely affected, perhaps by some intentional act exclusion or something like that in the policy. So there are ramifications there with the effect of a guilty plea. Obviously, with respect to the driver, it will affect adversely and probably forever nullify any future employment prospects. So there are, and we'll talk a little bit about inadequate counsel later, but there are several adverse consequences of the criminal charge and a criminal plea to a criminal charge or a conviction of a criminal charge. Katie, are you doing this one? Okay. And Katie will take over from here about minimizing driver involvement at the scene.
So taking into account everything that Jim's spoken about with the criminal penalties that could be facing your driver from an accident, it's important to minimize the driver's involvement at the accident scene like this slide says. So one of the key ways you can do that is to make sure that there is someone with the driver there as soon as possible, whether that's an attorney or a field investigator or someone from the company. It's important to have someone there as soon as possible to make sure that there's someone there looking out for both the driver and the company and protecting their interest in the investigation. As we talked about before, it's common for drivers to want to apologize for being involved in an accident or to explain why the accident happened. If there's someone there to protect the driver, those statements are less and less frequent and they don't harm you being the company further down the line in litigation. One way that companies can do this is by having company first responders or an accident response process. The process would provide some uniformity of responding to accidents so that when an accident occurs, there's no panicking among employees and employees know exactly what needs to get done and who needs to be contacted in what order. It also shows that the company takes safety seriously. The fact that a company is willing to invest resources in ensuring that an accident is appropriately responded to goes a long way in kind of shoring up a jury or the public's confidence in a company's seriousness in handling accidents. And one thing that our group does is we've developed our own mini accident response program with a list of important phone numbers and people to be contacted when we get called out by clients to investigate accidents. As we discussed, it's important to control access not only to the driver, but also to the tractor and trailer and any other equipment that could be on the scene. Police, like Jim said, are very well trained in what to look for and what questions to ask. And so by kind of running interference with the police and other investigating parties, you can make sure that any adverse information isn't, the focal point of the investigation, and you can control what is said to the police. Obviously, the police report is a very large part of litigation moving forward, so it's important to make sure that the information that is recorded there is accurate and is truthful in what actually happened at the accident. We talked a lot about medications and the role that they can play. Whoever is on the scene first needs to get into the tractor cab and make sure that any medication or pets are secured and that the access to them is being controlled. Oftentimes, pets are a violation of company policy, so you want to make sure that if you have any pets on the scene, that they are accounted for and that it is well known by everyone involved that that was the case. Lastly, we say get him or her out of there. We're referring to the driver. There's no need for the driver to hang around at the accident scene. It only leads to bad consequences. The driver is usually, as Jim said, emotionally unstable, and for him or her to just hang out and see the damage that has been caused, it's often very unsettling. And so it's just best to get him or her away from the scene as quickly as possible.
Thank you, Katie. We're going to talk now a little bit about Section 390.15 of the Federal Motor Carrier Safety Regulations. And what this is, it's a statutory requirement that in accidents, the motor carrier is required to provide information and to make records and information available to the Federal Motor Carrier Safety Administration or an authorized state or local law enforcement agency or representative with respect to their investigation of the accident. So it's a statutory mandate that there must be cooperation when requested by a governmental authority who's investigating the accident. This is not a voluntary action that the company can decide, well, we're just not going to do this until, you know, there's a criminal charge or there's a civil lawsuit. There's a statutory requirement, a regulatory requirement that the motor carrier cooperate. They have to give all reasonable assistance in the investigation of the accident, and they have to answer questions with respect to any inquiries. Oftentimes that will require that the driver come back at a pre-designated time after the accident, maybe a day or two afterwards, to sit down with investigating authorities and provide a formal recorded and sometimes videotaped statement. And when those situations arise, it's critically important that that driver is accompanied by counsel for those types of interviews. Also, for accidents now, the motor carrier has to provide or has to maintain an accident register for 3 years after the date of each accident. And these accident registers are frequently demanded in civil litigation by plaintiffs' attorneys, and they have a fundamental misunderstanding of what they are. But basically, the accident register has to include the date of the accident, the location of the accident, the driver's names, the number of injuries, if there were any fatalities, whether or not there were any hazardous materials spilled or discharged, and then also copies of all accident reports required by the state or governmental authorities or entities or insurers. Now, these are not plaintiffs' attorneys go after this information thinking that it would include internal accident investigation reports or written event summaries or similar things that are the product of the claims department for the motor carrier or the insurer for the motor carrier's investigation process. That's not what these things include. It would be accident reports that they have to submit as required by a governmental agency, and those would have to be maintained in the accident register. It's not their internal reports. It's certainly nothing that would go to or between the motor carrier or the insurer and counsel. The effect upon this for drivers' rights is you have this inherent clash between the motor carrier's statutory obligations to provide information to the investigating authorities under 390.15, that at the same time that the motor carrier is providing this information to the investigating authorities, which they're required to do, they're perhaps providing potentially incriminating information to the governmental authorities that may support criminal charges against their driver. So they're actually helping the state prove their case against the driver when they're providing this information, but really the motor carriers don't have much of a choice when they're being asked to provide certain information. But what the attorneys can do in these types of situations, and what we try to do, is intervene and control the flow of information, and at least from the attorney's perspective, to review it before it's sent out to make sure if there are any red flags in the information we're providing, that we can proactively respond to any potential problems. The potential for abuse is I think pretty obvious, in that the state, in requesting these information pursuant to 390.15, can, on their face, be requesting the information on the basis of a safety investigation, or to determine, for a police accident report, what the cause of the accident was. But at the same time, they're looking at it with an eye cast towards the driver for potential criminal charges. The national, sometimes in more serious accidents or accidents involving multiple fatalities, such as between perhaps a tractor trailer and a passenger bus, or a van, a passenger van with multiple fatalities in it, the National Transportation Safety Board will get involved, and that presents an entirely different set of concerns and problems for the motor carrier, and then it's an entirely different conduit, a potential conduit for information to flow from the motor carrier about its driver, about its safety programs, about its training programs that the National Transportation Safety Board's going to want to know, and certainly has the right to know. The company has a duty to comply with these requests and mandates issued by the National Transportation Safety Board, as does the driver. So as we'll talk about shortly, in those types of situations where it looks like it's a really bad accident with the National Transportation Safety Board involved and there's likely criminal charges, it's critically imperative, based on our opinions and our experience, that separate criminal counsel get retained for the driver. So when do you do that? Well, you do that when right away, when it looks like there's going to be some criminal component to the investigation. If it looks right away, if you can tell by being on the scene or gathering information from the driver or from the company or from the people that are present at the scene, that this looks like an accident that was at least initially caused by some potentially criminally negligent conduct of the driver, whether he was over hours, whether he was fatigued, whether he was off his meds, whether he was on the phone, whether he had, several large animals roaming about the tractor cab that were affecting his ability to stay focused in the roadway. You'll know, based on experience, if you've been to enough of these accident scenes, when this is going to be a problem. So what you have to do when you make those assessments, you have to decide right away, and it's our position, it's always better to err on the side of caution when it looks like there are criminal charges pending, to talk with the motor carrier and make sure that criminal defense counsel is assigned right away along with your investigation of the accident, because as we've talked about, as we'll talk about shortly, is that sometimes the interests can not necessarily converge, and they can be on different pages. The driver's interests with respect to avoiding criminal charges, or at least mitigating criminal charges, can be different than the company's interests with respect to a civil lawsuit, a potential civil lawsuit. And our recommendation with respect to who pays for the criminal defense attorney, if it's an employee driver, it's our recommendation and our experience that the company foots the bill for the criminal defense attorney. The drivers often don't have the means to fund their own criminal defense. They don't have the money on hand to pay a large retainer. The criminal defense attorney's rates, if they're good criminal defense attorneys, are typically higher than what the company pays for its civil litigation defense attorneys. So there needs to be clarity at that initial retention stage between the motor carrier or the motor carrier's insurer and the criminal defense attorney with respect to what their roles are, what their rates are, what their retainer is going to be, and things of that nature. So it's important to get those things clarified up front once the decision is made that criminal defense counsel is necessary. The criminal attorney and the civil attorney work together in the initial investigation. They work together in the criminal proceedings. In the civil suit that's ultimately filed resulting from these accidents, the criminal attorney would be part of the discovery response process to make sure that through coordination with civil defense counsel that there's nothing in the discovery responses that could potentially adversely affect the driver's constitutional rights or criminal defenses. The same thing with depositions. We'll talk about getting stays shortly, but in the events that there is a driver that's not yet been criminally charged, but it may happen, and you think it's likely to happen, you want to be really careful. If you're forced to produce the driver for deposition, you want to make sure that that's done in coordination with the criminal defense attorney, so that nothing incriminating can be said at the depositions. It's also important too, if you're deposing, say, for example, the investigating officers or troopers that are associated or that investigated the accident. The criminal defense attorney can provide critical guidance to the civil defense attorney in questioning whether or when the driver was given his or her Miranda warnings, like we talked about before, whether a particular statement given during the investigation, which, while it may be admissible in the civil case, potentially could be inadmissible in the criminal case because the statement was given in a situation where the driver wasn't properly given his or her Miranda warnings. And a criminal attorney working with the civil attorney to make sure those questions are asked of the troopers at time of deposition would be critical in the driver's ultimate criminal defense. Also, with respect to document production as well, the criminal defense attorney, if he or she's going to adequately protect the driver's constitutional rights in the event of potential criminal action, needs to know what documents are being produced. Ultimately, it really comes down to what the best interests of the driver are. Again, there are going to be situations where it's going to be in the driver's best interest from a constitutional perspective, from a criminal perspective, certainly, to avoid saying certain things or avoid being produced to say certain things, which may ultimately conflict with the company's interest in perhaps seeking an early resolution of a lawsuit or something along those lines, or trying to pin the blame for the accident on some other party or company. But ultimately, what we're talking about here is the driver's constitutional rights and the company's obligations to do what it needs to do to protect the driver from incarceration as a result of not having adequate counsel or adequate guidance through this process. In situations where there's a criminal case pending, where perhaps the district attorney's office has investigated the accident and still has a long time to go before the criminal statute of limitations expires, but it looks like there's going to be a lawsuit filed. But in the intervening time, there's a civil lawsuit filed. These are situations that are, again, particularly problematic for the driver, because the driver is going to be oftentimes sued along with the company. And we'll talk about that shortly. When they're not sued, actually is more of a problem for the company or for the driver. But oftentimes the driver and the company are sued in a wrongful death civil lawsuit, which then triggers obligations under the state or federal rules to produce certain documents and to be produced for sworn deposition testimony. And what we find is particularly sometimes disconcerting is that we'll have plaintiff's attorneys who are often well connected in the community where the lawsuit is being filed, often work in not necessarily concert, but certainly their interests are aligned, as the plaintiff's attorney's interests are to demonstrate that the driver was negligent under the common law. So is the district attorney interested in gathering evidence and demonstrating that the driver was criminally negligent. So they're often acting in concert, and you'll see this at depositions where the plaintiff's attorney will have issued a subpoena to the state trooper, and you'll find out through your questioning of the state trooper that the state trooper and the plaintiff's attorney have met and conferred several times and reviewed the police accident report, and the state trooper or the investigating officer was teed up to give a lot of really damaging testimony against your driver. And again, that's something you need to flesh out during that person's deposition. And again, that's another really good reason why you need to have criminal counsel present during this process, because the criminal counsel can assist you in directing questions to the investigating officer about the statements provided and the circumstances under which the statements by the driver were provided, which you could hopefully preclude in a subsequent criminal proceeding. You wouldn't be able to preclude them in a civil case, but you can certainly preclude them under the Fifth Amendment if they were given without proper Miranda warnings. And that's why you need the criminal attorney there to assist in that process. Our recommendation when there's a civil suit that is filed after criminal charges are filed or while criminal charges are pending, we always move to stay the civil proceeding, and we try to make our stay as broad as possible. Ultimately, our goal is to stay the entire proceeding so that nothing happens until the criminal case is resolved. Again, and the primary reason that we argue to the courts is that anything done or said or produced as part of the civil litigation with its broad discovery rules under the federal and state rules have a very real potential to adversely affect the driver's constitutional rights. So our argument to the court is, listen, this thing has to stop until the criminal case is resolved. And the trends and obviously the plaintiff's attorneys are going to vehemently and aggressively challenge those types of motions. And under many circumstances, and the trends, at least with respect to the jurisdictions where we practice, is that the courts are reluctant to stay entire proceedings, at least where the driver is a party to the civil proceeding. And what they'll do is they'll preclude the driver from being deposed in the civil case, but they'll allow the remaining discovery to proceed. And while that's better than nothing, it's problematic in that it still allows the investigating officers to be deposed, other potentially adverse witnesses to be deposed, and things of that nature. So it's better than nothing, but it still makes it difficult. And in those situations where there is a partial stay and the driver's protected from being deposed in the civil case, it's still important to have criminal counsel involved in the process because, like we said before, with respect to the investigating officers who are being deposed, you need to have criminal counsel there to monitor and keep an eye on things and to protect the driver's rights down the road. In many cases, or in more and more cases, the plaintiff's bar has gotten quite clever in situations with employee drivers where the plaintiff's attorney will file the civil wrongful death suit against the company and not include the driver as a defendant. And the reason they do that, particularly where the driver is an employee of the company, is that they already have, by virtue of the driver being an employee, they don't really need to have the driver in the civil suit. And by not having the driver in the civil suit, it's much more difficult to get a stay because the courts, like I said, are more interested in protecting against the deposition of the driver. And if the driver is not part of the lawsuit, it's easier for the plaintiff's attorney to say, well, Judge, the driver is not part of this. We can still go after the company because he's not the one being criminally charged. But what happens is with the clever plaintiff's attorneys, they're going to still work in concert with the law enforcement officials who are deposed and the witnesses who are being deposed to not only prove their case, but to develop evidence that may, on a parallel track, adversely affect the constitutional rights of the driver. So when you get situations like that where the driver is not a party, you can be sure that one of the reasons they're trying to do that is to avoid the imposition of a stay on the civil case by arguing that the driver is not part of it. The effects of a plea in a criminal case can be quite severe. With respect to a civil case, the plea or the outcome is admissible. It affects every part of the civil litigation process. Obviously, it's a critical component of discovery. Things that are part of the criminal case would be in the civil case. Again, there are insurance coverage issues with respect to the potential criminality, the criminal conduct of the driver, whether or not that driver's conduct is considered intentional conduct, which would void certain provisions of an insurance policy and cause problems for the company. And also with respect to serious lawsuits, the criminal conviction or criminal plea of a driver can be imputed back to the company to further support and strengthen the claim or the argument that the company and the company's hiring practices and retention practices and training practices were woefully insufficient to have allowed this type of criminal conduct to have occurred by one of its employees. So there's no good that can come of it, particularly with the company. It can only be bad, even if, the plaintiff's attorneys are very good at connecting back the conduct of the company, the alleged conduct of the company, to the conduct of the driver. So these criminal cases have a lot of negative components to them that, to the extent possible, as part of the first response, competent counsel can mitigate. And that's why we're so strongly in favor of and a proponent of having competent counsel respond to serious accident scenes, and where there are situations where there are potential criminal charges, to make sure that the driver's interests are protected, because by protecting the driver's constitutional rights with respect to self-incrimination, respect to he or she saying something that they shouldn't say at the accident scene, at the same time you're doing the company a big favor down the road in any potential civil litigation. So that's our presentation for today. Again, if you have any questions, please contact either Katie or myself by email. Thank you for attending our webinar, which has been titled The Intersection of Criminal Law and Trucking. And you can learn more about this program and other Weber Gallagher events by visiting our website at www.wglaw.com. Thank you.